In court, my ex's lawyer said, she's broke. She can't afford a home or food for her kids. Why should she get them? The judge nodded. I stayed silent, holding tears. Then my 7-year-old stood up. Can I show the judge the letter I found in Dad's safe? The room fell silent. The judge read it, then looked up, shocked. Even my ex went pale. I want to walk you through everything that led to that moment, because the version his lawyer told the court that morning was only true in the way a photograph is true. It shows what's in the frame. It doesn't show what's standing just outside it or what it took to get everyone into that particular arrangement of light. The courtroom was smaller than I expected. County family court, 3rd floor, a room built for maybe 40 people that somehow felt both cramped and too large at once. I remember the fluorescent lighting most of all, the way it made everyone look a little sick, a little washed out, like we were all extras in someone else's worst day. I sat on a bench that wasn't built for sitting through 4 hours of testimony. My son sat beside me in his good shirt, the one with the collar he hated, swinging his feet because they didn't reach the floor. I'd told him only that the judge might ask him some questions, and that if that happened, he should just tell the truth. I hadn't told him anything else. I didn't think there'd be anything else to tell. 6 years ago, when I married him, I had a job I liked in medical billing, a car that was mine outright, and a husband who used to ask what I thought about things before he made decisions. I want to be fair to the person he was then, because he wasn't always who he became. He used to leave notes in my lunch bag. He learned to make my mother's arroz con pollo because I mentioned once offhand that I missed it. For the first 2 years, I would have told you I got lucky. The shift was slow enough that I couldn't point to a single day and say, that's when it started. It wasn't a day. It was 1,000 small adjustments, each one reasonable enough on its own that objecting to it would have made me the unreasonable one. It started with the budget spreadsheet. He set it up himself, said it would help us save for a house, and for a while it did feel collaborative. Then the questions started attaching themselves to every line. Why did I need a $12 lunch when I could bring one from home? Why did I buy a birthday gift for a coworker I'd only known 8 months? Nothing was ever phrased as an accusation. It was always framed as concern, as him trying to understand my thinking, as though my thinking were a foreign language he was patiently learning to translate. After our son was born, the questions got sharper, but so did his justifications for asking them. We have a kid to think about now, he'd say whenever I pushed back, as if wanting to buy myself a coffee meant I'd stopped thinking about our son, as if the two things were in competition and I kept choosing wrong. I stopped seeing my 2 closest friends around that time, not because he told me to, exactly, but because every time I made plans, he'd ask why I needed to go out when I could see them another time, when the baby was older, when things were less hectic. Every individual request to reschedule sounded so reasonable. It was only in aggregate, looking back, that I could see the shape of what had actually happened. By the time our son turned 2, I hadn't had a night out without my husband in over a year, and I genuinely couldn't have told you the exact date that had become true. It had just become true the way water becomes ice. Not all at once, but not gradually enough that you notice the exact moment it stops being able to move. I used to lie awake some nights doing the math on it, trying to locate the turn. I never found one. There wasn't a turn. There was just a slope, and I'd been standing on it long enough that level ground had started to feel like an incline. He left on a Tuesday in March while I was at work. I came home to a closet that was half empty and a note on the kitchen counter that managed to be both brief and somehow still self-pitying, something about needing space to figure out what he wanted. What he wanted, it turned out, was someone he'd met at his gym 4 months earlier. I found that out from a mutual friend 2 weeks later, not from him. The financial reality took longer to surface than the emotional one, and it was worse. Our joint account, which I'd assumed held something close to what we'd been putting away for a down payment, had less than $400 in it. He'd been moving money for months, it turned out, into an account I didn't have access to, under the explanation, when I finally got him to explain anything, that he'd needed a cushion in case things didn't work out between us, as though he'd been quietly preparing an exit for longer than I'd known there was a door. He kept a newer car. I kept our son, the apartment lease with both our names on it, and a stack of bills that still had his name on half of them, which meant every collections call came addressed to both of us and answered by only one of us. I want to describe what the next year was like without making it sound worse than it was, because plenty of people have survived worse, and plenty of people have survived it with less support than I eventually found. But I also don't want to sand the edges off it, because the edges are the point. I took a second job cleaning offices at night, cash paid, because I couldn't survive the 6-week gap before my first unemployment check cleared. I'd drop my son at my neighbor's apartment after his bedtime routine, drive to a building downtown, clean 4 floors of it alongside 2 other women who became, in their own way, the closest thing I had to friends that year, and get home around 2 in the morning to sleep for 4 hours before doing it again as a mother in the daylight. The water heater broke in October and stayed broken until December, because the landlord's idea of urgency didn't match mine and I didn't have the leverage to insist. We boiled water on the stove for baths. My son thought this was an adventure for the first 2 weeks. By week 6, he'd stopped mentioning it, which somehow felt worse than if he'd complained. He never once asked why we were living the way we were living. Kids absorb a new normal faster than adults do, I think, because they haven't built up as many memories of what normal used to look like to compare it against. He was 5 when his father left, 6 by the time the worst of it had leveled out into something merely difficult instead of acute. He doesn't remember the version of our life before, not really. He remembers bleach smell on Tuesdays because that was the night I cleaned the dental office 2 blocks from his school, and I'd pick him up from my neighbors still in my work clothes. I'm telling you all of this not to ask for sympathy, though I won't pretend I'd mind some. I'm telling you because it matters for what came later. In that courtroom, when a very well-dressed woman woman stood up and used every one of these facts as evidence that I was the wrong choice to raise my own son. The custody filing arrived by certified mail on a Thursday in January, a little over a year after he'd left. I remember signing for it and thinking, stupidly, that certified mail meant something was being taken seriously, and wondering what exactly he thought needed that level of formality between us. He was asking for primary custody, not increased visitation, not a revised schedule. Primary. The petition cited, among other things, financial instability in the mother's household and inconsistent living conditions as grounds for the court to reconsider what had, until then, been an informal arrangement where our son lived with me and saw his father every other weekend when his father remembered to show up for it. I hired a lawyer I couldn't afford, a legal aid attorney named Priya, who took my case at a steeply reduced rate because the legal aid office was backed up 11 weeks, and she said, when I called her directly, that 11 weeks wasn't something a custody case could wait on. I liked her immediately. She had the specific kind of calm that comes from having seen 100 versions of your exact situation and knowing, in granular detail, which parts were dangerous and which parts only felt dangerous. She told me something in our first meeting that I held on to for the next 4 months. Courts aren't supposed to weigh poverty against a parent, she said. It's not supposed to be disqualifying on its own. I remember asking her, supposed to be like there was a gap between the rule and the room where the rule got applied. She didn't answer that directly. She just said we'd make sure the record was clean, and that clean records were the best protection there was. I spent those 4 months building that record. I kept every receipt. I documented every visitation exchange, every late arrival, every canceled weekend, because Priya said patterns mattered more than isolated incidents, and I wanted, more than I wanted almost anything else in my life at that point, to walk into that courtroom with a record so clean that nobody could find a seam in it. There was a mandatory custody evaluation somewhere in the middle of those 4 months. A home visit from a court-appointed evaluator who spent 90 minutes in my apartment asking questions I'd rehearsed answers to, and some I hadn't. She looked in the refrigerator. She asked my son, alone, in a separate room, whether he felt safe, whether he had enough to eat, whether anyone in the household made him feel afraid. I sat in the kitchen during that part, unable to hear the actual questions. Running through every possible way, a 7-year-old's honest answers to those questions could be twisted into something damaging in a written report I wouldn't get to see until it was already filed. The evaluation came back favorable, mostly with a line about financial precarity that Priya said was fairly standard boilerplate, and not, on its own, cause for alarm. I didn't fully believe her, not because I doubted her expertise, but because I'd stopped trusting any assessment of my situation that used a word as clinical as precarity to describe 2 months of boiling water on a stove. I didn't sleep well in the weeks leading up to the hearing date. I'd lie awake running through what his lawyer might say, rehearsing answers to accusations that hadn't been made yet, trying to armor myself in advance against a version of the hearing that existed only in my own head. It turned out I hadn't imagined the worst version. I'd imagined a milder one. The hearing itself started with the kind of procedural throat clearing that makes every family court proceeding feel, for the first 10 minutes, oddly indistinguishable from any other one. The clerk called the case number. The judge, a heavy-set man in his 60s, confirmed both parties were present and represented, noted the presence of the minor child in the gallery, and asked, in a voice that gave away nothing about which way he was leaning, whether either side wished to make an opening statement before evidence was entered. His lawyer stood up first. I hadn't met her before that morning, only knew her from the letterhead on his filing, a firm downtown with a name that took up 2 lines on the letterhead. She was polished in a way that made my one good blazer feel like a costume, and she opened with a photograph. Your Honor, I'd like to enter into evidence a series of images of the petitioner's current residence. She clicked through slides on a laptop connected to a screen at the front of the room. His new house, 3 bedrooms, a yard, a kitchen with an island in it. Then, without transition, a photograph of the outside of my apartment building, the paint peeling near the 2nd floor railing, a photo I hadn't known existed and couldn't imagine how she'd gotten. And this, she said, is where the respondent currently resides with the minor child. I felt my face go hot. Priya's hand found my forearm under the table, a small pressure that meant stay still, let it happen, we'll get our turn. The lawyer moved through her opening with the rhythm of someone who'd given a version of this speech many times before, to many other judges, about many other mothers. She talked about stability. She talked about continuity of environment. She referenced, at one point, a study on childhood outcomes correlated with household income that Priya would later argue in her own rebuttal had been selectively quoted in a way that misrepresented its actual findings. She used the phrase financially precarious household twice in 4 minutes, like she was testing which version landed better. Then she got to the line I'd been dreading since I first read the filing, the one I'd rehearsed 100 defensive responses to in the dark and still wasn't ready for when it actually arrived. She's broke, she said, gesturing toward me the way you might gesture at an exhibit rather than a person. She can't afford a home or food for her kids. Why should she get them? The judge nodded. Not a dramatic nod, nothing that would read as a verdict on its own, but a nod, the kind that meant the point had landed somewhere and was being logged. I watched him make a note on the legal pad in front of him, and I had no idea what the note said, and not knowing was its own particular kind of agony. I stayed silent. Priya had prepared me for this part specifically, told me that anger in that chair reads as instability faster than almost anything else a judge sees, that the calculus in family court is unfair in exactly this way, that a mother crying is sympathetic, but a mother angry is a liability. So I sat there holding my hands together in my lap so no one would see them shake, holding back tears I didn't fully understand the shape of, whether they were grief or fury, or just 4 straight years of exhaustion finally finding a room quiet enough to surface in. I looked over at my son. He was watching the lawyer with an expression I couldn't quite read, something more focused than a 7-year-old usually manages to hold for that long. I assumed he was bored or confused or both. I had no idea in that moment that he was doing something closer to calculating. For the first 20 minutes of testimony, it seemed like we might find our footing. Priya stood when the judge invited rebuttal and made the argument she'd prepared, the one she'd walked me through a dozen times in her cramped office with the water-stained ceiling tile. Financial hardship following a divorce, she said, is not on its own evidence of unfit parenting. The court has an obligation to distinguish between poverty and neglect, and the petitioner's filing conflates the two without offering a single instance of actual harm to the child. The judge allowed it. He made a note, longer than the one he'd made during opposing counsel's opening. For about 90 seconds, sitting there in my one blazer with my hands finally starting to unclench, I let myself believe we had found the seam in their argument, the place where it would come apart under its own weight. Then his lawyer stood back up, unbothered, and produced a second set of exhibits I hadn't known she had. My bank statements, the actual documents this time, printed and highlighted in yellow, laid out on an easel beside blown-up photographs of his new kitchen island. Your Honor, the court is permitted to consider whatever it deems relevant to the child's welfare, she said, and the judge, without much visible deliberation, agreed that he was. Priya's objection got overruled in under a minute. Whatever ground we'd gained evaporated exactly as fast as it had appeared, and I understood, watching it happen, that the court can consider financial hardship was a rule with far less weight behind it than the phrase suggested. We needed something they couldn't argue around on relevance grounds. I didn't have that yet. I didn't know, at that moment, that someone in the room already did. After that, it moved fast in the wrong direction. His lawyer walked the judge through a printed timeline of every late payment on my credit report since the separation, narrating each one like a small confession I'd made without meaning to. She used the word instability 4 times inside of 6 minutes. I know because I counted, silently, because counting was the only thing I could find to do with my hands that didn't involve wringing them in front of a judge who was already weighing whether I was too fragile to raise my own child. My ex sat at the other table with his arms crossed, nodding along at intervals like a man watching a bet he'd placed pay off exactly the way he'd expected it to. He hadn't looked at me once since the hearing started. He had, a few times, glanced at our son, and each time the look on his face was harder to read than I wanted it to be. Priya tried to redirect twice more, both times on grounds that seemed to get a little thinner each time the judge weighed them, a little more inclined to favor the version of relevance the other side was arguing for. I remember the specific, cold clarity of the thought that arrived somewhere in that stretch. We are going to lose this. Not a panic. Something quieter and worse than panic. Something closer to arithmetic. I had no more cards. Everything Priya and I had built over 4 months of documentation was sitting on the table in front of us, and none of it seemed to weigh anything against a well-lit photograph of a kitchen island. My son sat very still beside me, which wasn't like him, his feet swinging slightly because they didn't reach the floor, his eyes moving between his father's lawyer and the judge with an expression I read, in the moment, as simple confusion. Kids get bored in courtrooms, I told myself. That's all this is. I had no idea, watching him, that he wasn't confused at all. I had no idea he was waiting. There's a specific kind of silence that settles over a courtroom when one side has clearly stopped fighting and started just enduring, and I could feel that silence closing in around our table sometime after the third exhibit. Priya kept working, kept objecting where objections were available, kept her voice level and professional, but I could see something in her posture shift too, some small recalibration from advocate to person bracing for a result. My ex's lawyer was winding toward a close. She'd stopped bothering to look at me directly, which felt worse somehow than the accusations themselves, like I'd already been filed under a category that no longer required eye contact. She was building toward a request, I could tell, the kind of rhetorical runway lawyers use before asking a judge for exactly what they came for. Your Honor, given the totality of the financial instability documented here, given the demonstrated pattern of inconsistent housing and inconsistent income, we would ask the court to consider that primary custody with the petitioner represents the more stable path forward for this child. I felt the room tilt slightly, the way it does when you hear a sentence you've been dreading finally assembled out loud in the order you feared it would come in. I looked down at my hands, still folded in my lap, still shaking slightly no matter how hard I tried to still them. I had nothing left to offer that moment. 4 months of documentation, every receipt and record Priya had helped me assemble, suddenly felt like it had been constructed for a different, gentler version of this hearing, one where financial hardship actually functioned as the neutral fact the law claimed it was supposed to be. I was not prepared for the version where it functioned as a verdict already halfway rendered. I don't know how long I sat there in that particular kind of silence, the one that isn't peaceful, the one that's really just the sound of a person running out of options in real time. It might have been 10 seconds. It felt considerably longer. That was when my son stood up. Can I show the judge the letter I found in Dad's safe? The room fell silent in a way that felt total, the specific kind of silence where even the low hum of the fluorescent lights seems to drop out for a second. Every head turned toward him at once, mine included, and for a moment I genuinely didn't understand what he meant. My mind was still catching up to the sound of his voice in a room built for adult voices, still trying to place what letter, what safe, what he could possibly be referring to. Then I remembered the backpack. 2 weeks before the hearing, while I was packing the last of our things out of what used to be our house, back when the arrangement still let me collect items we'd left behind, I found found an envelope wedged behind the insurance documents in the fire safe in what used to be his home office. I still had the code. He'd never bothered to change it, which told me something about how little he thought I'd ever go looking, or how little he thought I'd understand what I found if I did. I don't fully know, even now, why I took it instead of leaving it where it was. I remember standing there with it in my hands for what felt like a long time, weighing something I couldn't name yet. Some instinct that it mattered before I'd even read past the first paragraph. I read it twice, standing in that office, and by the second read, my hands weren't entirely steady. I didn't tell Priya about it. I want to be honest about that, because it's the part of this story that still unsettles me a little even now. I didn't tell my lawyer I had it. I told myself it was because I wasn't sure it would hold up. Wasn't sure a judge would weigh a private letter the way I weighed it. Wasn't sure I could get it entered as evidence through any channel that wouldn't immediately raise questions about how I'd come to have it. All of that was true. None of it was the real reason. The real reason was that I was afraid. I was afraid that if I handed it to Priya, it would become a legal exhibit with a number stamped on it, filtered through motions and objections and procedural timing, and that somewhere in that process, the actual weight of what it said would get lost, the way important things sometimes get lost in the machinery built to handle them. I wanted it to land exactly once, exactly as written, in front of the one person whose read of it actually mattered. So that morning, before we left for the courthouse, I folded the 3 pages into my son's backpack, tucked inside the plastic homework folder he carried every day, in a place I knew he'd never think to look on his own. I told him only one thing. I said, if the judge ever asks whether anyone else wants to say something, you can raise your hand. That's all I said. I didn't tell him what was in the folder. I didn't tell him it existed. I have turned that decision over in my mind more times than I can count in the time since. Whether it was fair to a 7-year-old, whether I should have found some other way, I still don't have a clean answer for that. I only know that somewhere between the courthouse parking lot and that moment in the hearing, he found it himself, read enough of it to understand it mattered, and decided on his own, without my prompting, that this was the moment to say something. The bailiff took a half step forward, uncertain, the way people get uncertain when a child does something unscripted in a room built entirely around scripts. The judge held up a hand, not unkindly, and the bailiff stopped. "Come on up," the judge said. His voice had shifted just slightly into something gentler than the tone he'd used for the rest of the hearing. "What do you have there?" My son walked to the bench with the 3 folded pages held in both hands, the way you'd carry something you'd been told was important without fully knowing why. His steps were steadier than mine had been at any point that morning. He handed the pages up without a word and stepped back to stand beside the bench, waiting, the way you wait when you've done the only thing you know how to do and have no idea yet whether it was the right thing. The judge unfolded the pages slowly, the way you'd handle something you didn't yet know the weight of. He read the first page in silence, his eyes moving with a steadiness that gave away nothing. I watched his face for any sign of what he was seeing and found none, which was its own kind of unbearable. He turned to the second page. Somewhere partway through it, something shifted, a small tightening around his eyes, the faint downward pull at the corner of his mouth that people get when they're recalibrating an assessment they'd already have made. He read more slowly after that, and at one point he went back, flipped to the first page again, as though double-checking something against what he'd just read on the second, before returning to where he'd left off. The courtroom had gone fully silent in a way I hadn't heard it go silent all morning, not even during the worst of the earlier testimony. Even his lawyer had stopped moving, her pen frozen mid-note on the legal pad in front of her, watching the judge's face with the specific alertness of someone who senses, before they have any confirmation of it, that something in the room has just changed shape. I could hear the air conditioning cycling somewhere above us, a sound I hadn't noticed once in the 3 hours before that moment, and I remember fixating on it, on the ordinary mechanical hum of it, because it was easier to listen to than the silence underneath it. My son's hand was still in mine. I hadn't noticed him take it, hadn't noticed the exact moment he'd stepped back from the bench and returned to sit beside me again, but there it was, small and warm and steadier than mine, and I held on to it the way you hold on to something when you've stopped being sure what happens next. By the third page, the judge looked up, not at me, not at Priya. He looked directly across the room at my ex, and held the look for long enough that a few people in the gallery behind us started shifting in their seats, sensing, the way rooms full of strangers sometimes collectively sense these things, that whatever came next was going to matter. He started, then seemed to reconsider the formality of it, given what he was holding. "Sir, do you recognize this document?" My ex's face had gone the color of the walls behind him, a kind of gray-white I'd genuinely never seen on him before, not during the worst arguments of our marriage, not even the night I confronted him about the woman from his gym. His lawyer leaned toward him, whispering something, and he didn't respond to her at all, didn't even turn his head, just kept staring at the judge like a man watching a door close from the wrong side of it. The letter, it turned out, was from a financial advisor my ex had consulted 4 months before he filed for custody. 4 months before any of this began in the courtroom sense, so clearly not 4 months before it began in the sense that actually mattered. The letter was dated, specific, unambiguous in a way that left no real room for the kind of reinterpretation his lawyer would try to offer later, once she'd recovered enough to try offering anything at all. It laid out, in the calm, procedural language of someone billing by the hour, a plan to restructure my ex's reported income and asset positioning ahead of what the letter explicitly called the anticipated custody evaluation. It named which accounts to close and in what order. It named a secondary account, one I hadn't known existed, opened under a business entity that turned out, according to the letter's own appendix, to have no actual operations behind it. It estimated, with something something close to actuarial precision how the resulting numbers would present to a family court judge assessing financial stability, going so far as to reference typical judicial weighting of income to housing ratios and custody determinations, as though my family's future were a spreadsheet variable to be optimized. And in the third paragraph, the one the judge had visibly paused on twice, it stated the strategic objective without euphemism, in language precise enough that no lawyer in the room would later be able to argue it meant something softer than what it plainly said, that the goal of these maneuvers was to position the respondent, meaning me, as financially unstable enough that she would have no credible path to contest a custody filing. The advisor had even, near the bottom of the page, flagged a projected timeline, estimating how many months of engineered financial pressure would be required before the disparity looked severe enough to a court to tip a custody determination decisively. The judge set the pages down on the bench in front of him with a deliberateness that felt almost ceremonial, squaring the edges of the 3 sheets against each other before he looked up again. He looked at my ex for a long moment before he spoke. "I'm going to ask you directly," he said. "Do you recognize this letter? And can you explain to this court what the third paragraph means, in your own words, out loud, for the record?" His lawyer half rose from her seat, said something about needing a moment to review the document's provenance before her client responded to its contents, and the judge, without raising his voice at all, told her to sit down. She sat down. Nobody in that courtroom moved. I could hear my own pulse, could feel my son's hand find mine somewhere in that silence, and grip it the way kids grip things when they've done something big and are only now, in the aftermath of doing it, starting to feel the size of it. My ex opened his mouth. Nothing came out the first time. He tried again, and what emerged wasn't an answer, wasn't really language at all, just a fractured half-sentence about context, about how things get taken out of context, about how his financial advisor had a habit of overstating things in writing that didn't reflect what they'd actually discussed. His lawyer had gone very still beside him, the particular stillness of someone doing rapid, silent math on how much of this she could still contain. "That's not what I asked," the judge said. His voice hadn't risen at all, which somehow made it land harder than if it had. "I asked whether you recognize this letter, and I asked you to explain the third paragraph, in your own words, for the record. Take your time. But I am going to have an answer before we adjourn." The silence that followed felt like it lasted considerably longer than it probably did. I watched my ex's jaw work, watched him glance once at his lawyer, who gave him nothing, no cue, no lifeline, because there was nothing left in her toolkit that applied to a document with his own advisor's letterhead on it, stating outright what the last 4 months had actually been for. "I consulted a financial planner," he finally said, each word arriving like it cost him something physical to produce. "After the separation, to understand my options. The letter states the objective was to make the respondent appear financially unstable enough to eliminate her ability to contest custody," the judge said, reading the line back almost verbatim, his eyes on the page rather than on my ex, which somehow felt more devastating than if he'd stared him down while saying it. "Is that an accurate description of what you discussed with this planner?" My ex didn't answer that one directly. He said something about not controlling how a third party chose to characterize their conversation in writing, something about intent being different from outcome, and I watched the judge's expression settle into something I can only describe as a very calm, very complete kind of disbelief, the look of a person who has just watched someone confirm, through the specific shape of their denial, the exact thing they were trying to deny. His lawyer tried once more, asking whether the court might allow a brief recess before her client responded further, framing it as a request to consult, though everyone in the room understood it as something closer to triage. The judge said no. He said it plainly, without any particular edge to it, the way you'd decline a request that had already answered itself. He said the court had given the petitioner ample opportunity to respond to a direct question about a document bearing his own advisor's signature, and that further delay wasn't going to change what was already sitting on the record. My ex tried one more time, a final attempt at reframing that came out sounding less like an explanation than a man watching his own account of events dissolve in real time under the weight of a document he clearly hadn't expected to see again, let alone see read aloud by a judge in front of the son it had been written to disadvantage. He said the letter represented preliminary planning, nothing final, nothing that had actually been acted on. The judge asked, without inflection, whether he'd like to explain the account closures referenced in paragraph 2, the ones the letter's own appendix confirmed had, in fact, been executed on the exact dates specified. My ex didn't have an answer for that one either. The judge set the letter down and addressed the room rather than either of us directly. He noted, for the record, that the document would be entered as an exhibit, that its authenticity and provenance would need to be formally established before the proceeding could conclude, and that given its contents, the court was suspending the custody hearing pending further review. He looked briefly at my ex's lawyer and said that he expected her office to cooperate fully with whatever discovery followed, in a tone that made clear this wasn't a request so much as a preview of what was coming. Then he looked at my son, really looked at him, the first time all morning any adult in that room had looked at him as anything other than a minor detail attached to a custody dispute. "That took a lot of courage," the judge said. "Thank you for bringing that to me." My son, who had been quiet through the entire exchange, who I don't think fully understood the scale of what had just happened in the room around him, only nodded, and then, in the specific unguarded way 7-year-olds sometimes puncture the gravity of a moment without meaning to, asked whether this meant we could still get lunch after, because he was hungry. A few people in the gallery actually laughed, a short, surprised, releasing kind of laugh, the sound a room makes when tension that's been building for hours finally has somewhere to go. Even the judge's mouth twitched at the corner, the first almost smile I'd seen from him all day. My My ex didn't laugh. He sat very still at his table, staring at the exhibit still resting on the bench, a document that had existed for months without his knowledge that it would ever leave the privacy of an email thread with his financial planner, that would ever be read aloud in a courtroom by a 7-year-old boy who'd found it because his mother had trusted him with something she hadn't fully trusted anyone else with. Not her lawyer, not her own instincts about whether it was fair to ask a child to carry that weight into a room like that one. I don't know. Sitting here writing this, whether it was fair, I've turned it over more times than I can count. I only know that when the bailiff finally called a 15-minute recess, and my son turned to me with the particular open, hopeful face of a kid checking whether he did good, I pulled him into my arms and held on for considerably longer than 15 minutes worth of recess actually allows for, and neither of us let go first.